Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Um, in this particular episode, this is the next in the series of the Trump deportation series. Um, and, if you look at all the ones I've done, it's essentially from the moment, for example, that you would be put in detention or served with the papers to begin the removal proceedings, to pleading to the NTA or the notice to appear, to going forward and having a contested hearing, to declaring what your forms of relief will be, to preparing, having the filing of the petitions, to then going to trial and presenting the evidence. So here we are at essentially the end of the immigration court proceedings, and the judge is about to make a decision on your case, whatever it is. If you applied for cancellation of removal, if you applied for asylum, withholding, registry, if you applied for waivers, whatever it happens to be, um, if you made arguments that the crime you committed, for example, was not an aggravated felon for various reasons, and you're not inadmissible, or you should, qualify for the petty theft exception, or you qualify for derivative citizenship, we could go on, but let's just say it's coming to the end. You've done the trial, you've done the evidence, judge has asked you the questions, and now the judge is going to make a decision. So, the reason for this particular video is not so much if the judge agrees, because if the judge agrees and grants your petition, which that's a possibility, then that means you're in. That means you either get to keep your green card, it means you're going to be able to get the green card, or it means that you qualify to stay here in the US and you won't be deported. So various items can occur from being approved by the judge. Now, um, the judge can also deny the uh, the petitions for various reasons, and the judge will go on record and will list all the reasons why the case is denied. And obviously, your attorney needs to sit there throughout that and take notes and so forth, so that when the judge makes the decision, there will be, and there always is, appealable issues, which you have a right to appeal. So whether you win or you lose, it may go up on appeal. So the way it works is once you are done with the immigration court, let's say you win. Okay, immigration, they have 30 days in which to appeal the decision to the Board of Immigration Appeals. Now, let's say you lose. You have 30 days in which to appeal the case to the Board of Immigration Appeals. This is essentially an organization in Virginia that 100% all over the nation, including Puerto Rico, all the immigration courts, once a decision's made, the respondent, which would be you, the person who's in detention, will have a right to appeal. That's part of the both the administrative law, and it's also part of our due process, which allows somebody who gets a decision which they don't agree with to go up and appeal. So the appealing, of course, has to be done within 30 days. Now, if you appeal 30 days and 5 minutes, uh, minus some exceptions, it's garbage. It won't happen. They can take as long as they want to make a decision on the appeal, but you have an absolute duty to make sure that the appeal to the Board of Immigration Appeals, or the BIA, is sent in a timely manner and isn't sent in such a manner that is going to be summarily dismissed. Unfortunately, when people think that they can appeal themselves, they fill out the paperwork, they make what they think are good arguments, they send it in, and sure enough, the majority of the time, the BIA summarily denies it within 30 days, basically saying there's no issues of appealability, there's no realistic chance that anything will go forward. They deny it, and ultimately that would become a final order of deportation. So if we're talking in the medical field, for example, and you break your arm or you break your leg, you don't decide to go to Rite Aid and buy yourself the plaster of Paris and some tape and decide to fix it yourself. Okay, you wouldn't even think of doing that. So I'm just a little confused sometimes why people think that they can go and appeal themselves just because they feel that they have strong arguments and the judge didn't understand what they were saying. You have to realize that the appeal itself is the majority of it, the vast majority of it, will be legal argument, citing cases and citing statutes and citing essentially parts of the transcript that show why the judge was incorrect in ruling the way the judge did. Your personal feelings as to the fact the judge might be wrong doesn't really play into the legal argument, and in fact many times and most times is irrelevant and just emotionally based to try to you know get what you want across. But obviously what you want to do is you want to win, and in order to win you need to get an attorney who knows what they're doing. Okay, so given that it goes up on appeal, most of the time what happens is the notice of appeal is filed first, and it lists the various issues as to why the person must or must not win. I mean, listing all the general issues. And then what will happen, assuming it's not summarily dismissed, is the person will then be able to have the opportunity to write an opening brief. So initially, the notice of appeal is sent. The immigration court will then send the transcripts and everything, the whole file, up to the BIA. Then you'll get notification from the BIA that basically it was not summarily dismissed, and you'll get a time to do the opening brief. Immigration will then get an opportunity to do an opposing brief. You then get to file a reply brief once you read what the opposition is, and then you can select whether you want oral argument or not at the BIA. Okay, and so it's a whole procedure goes forward, and of course the hope is that once it gets to the BIA and you do the brief and the appeal, that it will be granted. So there's different things that could happen once it gets up to the appeal. First of all, there's an automatic stay of deportation once it gets to the BIA. So if you're afraid that, the moment you might lose at the immigration court, they're going to kick you out of the country, that is not the case. You get an automatic stay of deportation during the appeal. Now, once the decision is made on the appeal, it could be, just flat out granting it, which is great. It could be flat out dismissing it, which means they're denying everything, or they can remand it back to the immigration court in order for them to decide on what to do or what not to do. So the the BIA can go several different ways depending. And just so you know, some people will think, okay, well, if the BIA denies my case, that's it, it's over, I'm out of here. But still, yet that's not the case. Let's just say that the BIA has denied the case. Um, it can go up to the circuit courts of appeal for what's called a petition for review, and that is going to be the particular area of my next Trump deportation series. So you will know that in actuality, appeals can go quite high, and sometimes you have to fight a few battles before you win the war. So hopefully this lets you know that even though you might have lost in immigration court, the battle is by no means over. It actually has a long way to go, and sometimes it's the only way that you can actually get the relief that is being sought. So if you like the video, click like, subscribe, and you can go ahead again and leave comments. Again, I have lots of good comments. I have lots of comments against. And again, the ones that are against are fine. Assuming that you don't cuss every other word and don't try to insult everybody under the sun. I don't mind comments either way. So more on the coming weeks. Thank you.